All right, thank you very much for coming to our December meeting. I hope that everybody got some lunch in the back. And I want to thank Jerry and Adrian and Paul for giving me the blessing to order the food, spending their money. Don't really have any announcements this week or this month, but I do want to ask for your help with a project that's going on district-wide that I think would be very good. And so I need folks, particularly from the debtors bar, if they're willing to help me. And so I'm sure you're all aware, a few years ago, Paul Giordano and some others established, throughout the district, they established BLESS, which is the Bankruptcy Law?
Education Series Foundation.
Okay, the Bankruptcy Law Education Series Foundation. And it is a charitable foundation that the purpose of which is to raise funds for pro bono assistance throughout the district. And the foundation has been successful in obtaining, amongst other fundings, a grant from the Middle District Bench Bar Fund. And I think it's not insignificant. I forget what the number is.
I think
Paul?
22,000.
So 22,000, and then the indications, as I understand it, from Jill Kelso, who's with the U.S. Trustee Program in Orlando, and she sort of, at least administratively, seems to be spearheading a lot of these efforts. She made the initial application to the Bench Bar Fund, or the Bench Bar Committee. Their expectation is that this would be a recurring grant. So that would be $22,000 a year throughout the district to fund pro bono, pro se assistant clinics in each of the districts. And the other bar associations have already established their own assistance clinics, and they're operating. And they generally, for instance, in Tampa, they staff it a couple hours a week, I think, and folks volunteer. And the funds are utilized for administrative things, including there's an employee, one of the districts, and maybe in Orlando they have a full-time or part-time administrative employee who would administer the program throughout the districts. And so to that end, recently, at the beginning, just a few months ago, we incorporated I forget what the entity is called, but I think it's something like the Middle District Pro Se Assistance Clinic, and it's incorporated, and it's intended to be the structural arm that's going to unite all the Pro Se Assistance Clinics. I, as the president of our association, serve on the board of that entity, and we had our first board meeting a couple weeks ago. And the other clinics were very anxious, not only willing, but anxious to help us establish our clinic. And so they're willing to sort of give us all of the materials. They have a whole handbook that discusses, forms to be signed at intake, evaluation of the debtor with a criteria. An important form that I really hadn't thought of, but is a release of the lawyer who's providing the legal advice or the assistance, and it's all prepackaged and ready to go for our utilization. I think what we would need to do is to organize it, find a home, presumably in the courthouse, for it, and staff it. And so I know there are others more qualified. If somebody wants to volunteer to sort of chair a little committee of 3 or 4 folks that want to help. If not, I'm glad to organize it all and sort of host the endeavor. But what I need is your help, is setting it up. I personally never represented a debtor, and I really wouldn't know how to start. And I think I could fill out the forms. I think I could do an asset and liability and exemption analysis, but I've never done it, and so I need your help with that respect. So if you're interested in participating, let me know. The grant from the Bench Bar Fund would cover essentially all of the overhead. So you're just volunteering your time. You're not volunteering, the paperwork or, and hopefully we can have some sort of clinic or walk-in hours operating in our division. Maybe by beginning of summer, June 1st or something like that, I think would be a reasonable goal. The bench bar committee has asked us already to report back on the use of the funds, and our division is the one that it's the only one that reports back saying we're still working on getting started. Everybody's up and running, and so I'd like to get up and running. So that's the one sort of announcement, is a call for your help. So.
Curiosity, who types, the debtors type their own petitions, or how does that all work?
I haven't seen the handbook or the manual that they've put together. I don't think that you're preparing the petitions for them. I don't, you're not.
Just giving them, yeah.
I don't think the volunteers are necessarily representing the debtors, but you're getting them started. I think all they get is a 1-hour consult or something like that. Lara, what do they do in Tampa?
Yeah, so in Tampa, before BLESS, we implemented a pro bono actual program, where it was a couple times a week. On certain days, we met with the judges to figure out when the best time for their 7s or 13s, and we did it like before the cattle calling, that kind of scenario, because that's when people get off of work and are able to come. So it was it was like lunchtime or afterwards, and we actually just gave them legal advice, pro bono legal advice. So now I think it's switching to this clinic scenario where you're not giving legal advice, but I'm no longer on the board and I haven't been involved in the switch over. But we still have the regular actual pro bono.
I imagine in terms of scheduling, or maybe it would be like between 11 and noon on the Thursdays that Judge Delano is here, and folks, be first come, first serve, or maybe they'd call a number to schedule an appointment or something like that. So it wouldn't be a huge contribution, time-wise.
Judge
Maybe.
McKeown would actually, we literally would say to the people, go outside the courtroom, turn right, go down the floor, and go see the person's waiting there to talk to you.
Yeah, our report to the bench bar committee, said the way we handle pro se assistance in our division is, Judge Delano asks Greg or someone else to step outside and help the debtor, and so we would do. I'm sure Greg would appreciate the help. I'm also sure that Greg will be one of the first to volunteer.
Absolutely.
I know he's interested in this. So, with that announcement, all of you know how to get a hold of me. Or we can chat after the meeting. We can get together. I'll get all the materials, and then we can figure out what sort of variation of the program works for our division and everyone's.
And just
schedules.
kind of going, as some background, Luis, I know that Stephanie Carr and Greg, we'd all had talked about trying to set up a more formal type clinic situation with Ave Maria, and that just never took traction because for some reason they want to have a clinic for estates and trusts. So I guess poor people need estate planning as well. So.
Well, that's not exactly.
So that never took any traction. So we were trying to get that going, and I would imagine that if we don't even want to deal with that.
Yeah, I was aware of that, and it was discussed at our last, at our first, sort of organizational board meeting. And I certainly don't want to undermine those efforts, but I know that Stephanie's been talking about them for some time, and it seems to me, especially if there's a prepackaged program that somebody can give us with all the forms and how to do it and a template. I mean, we could get up and running with this relatively quickly in a matter of months, and then if it can grow into something bigger, I think that would be better.
I actually had a pro se debtor this week who came in, and when I told him he had some issues with his exemptions, he says, well, I went to this pro se clinic in Tampa a few years ago, and this is what they
Right.
Collier Legal Aid has
Yeah.
a pretty good setup, and that's
Okay.
who I've been kind of getting my cases from on a pro bono basis. They're probably a good source for materials as well.
Yeah.
And at least kind of figuring out the format of it and the logistics of it. So, I mean, that'll be a resource for us, but yeah. I'll be glad to help out. whatever you
Appreciate
need.
it. All right, and then now you've eaten your lunch, what you all really came for is Lara Fernandez is going to give us a brief case law update on some recent 11th Circuit decisions. I know many of you in the room know Lara. You've had cases with her, but she's a shareholder at Trenam in Tampa. She's been there for a little over 10 years after having served as a career law clerk to Judge Pasquet. So frequent visitor here in Fort Myers. Lara is the practice group leader of the Creditors' Rights, Bankruptcy and Insolvency Group at Trenam. And
She's kind of a big deal.
kind of a big deal. So, with that,
Former
Lara
past president
Fernandez.
of the Tampa Bay Bankruptcy Bar Association.
Great. Well, I told Luis, I was a little ill prepared, I've got a lot of stuff going on, and he said, I'll make this you don't have to have a very long presentation, so he did a great job with the whole pro bono discussion, because it really ate into my time. No. I'm a member of the federal bar and Tampa chapter, and every month that bar provides to its members a summary of every single circuit's rulings. It comes out monthly. So I got a lot of my materials, and Susan Sharp from Strichter Rydell is the one who actually does the summaries for the 11th Circuit. So I did utilize her materials when I was kind of looking to see what I wanted to talk about today. There are a ton of cases, and so I thought, well, instead of just giving you a summary, because you could do all that kind of yourself, especially if you read the federal bar or if you get it, I thought maybe I would talk about 3 cases that I think are pretty interesting. And then I also, 11s are kind of down. I wasn't sure what kind of bar constituent I have, so I picked a Chapter 11 case, but it's more about interpreting documents, loan documents and whatnot, so I think that has a lot of implications across the board for all creditors and debtors. I picked a Chapter 13 case, but it's FDCPA kind of violations, and so I kind of thought that was good actually for the creditor side. I represent a lot of creditors as well. And then I picked another Chapter 11 case, but it's a Chapter 11, it's a liquidating trustee that was appointed in that case, and so it was kind of post-confirmation issues. So I think they're pretty applicable to probably Chapter 7 trustees, so a lot of Chapter 7 cases. So the first case, and I have a little written material that I sent to Luis, and maybe afterwards he could just send it out to everybody so that you have at least the 3 cases that I wanted to talk about. The first case was just decided on August 31st. It's called JPMCC, and it's really, the debtor is Sagamore Partners Ltd. It comes out of Miami. Sagamore Partners is a hotel, and its lender, it was a regular lender, but the loan had been sold off to some type of non-traditional lender. And I think it was about a $35 million debt, and somehow, for whatever reason, the debtor didn't make a payment, but the loan had not matured. So in the underlying bankruptcy case, the owner of the hotel, who's the principal, proposed a plan, or before the bankruptcy happened, the loan documents actually say that the borrower waives default notice. But then there's another provision in the loan documents that says that the lender does need to send out notice for certain things, but not in event of default. And it's very, very clear. So what happened is that the borrower didn't pay an interest payment, and the lender did send a notice to the borrower, but not to New York counsel, which is what the notice provided for in the actual loan documents. And then the debtor still didn't make any payments, didn't cure, and so the lender initiated a foreclosure action. Then, during the foreclosure action, the debtor filed bankruptcy. During the foreclosure action, the lender just determined that as a result of the event of default, it would charge the default rate of interest. the debtor filed a plan that initially said that he was going, that the debtor was going to cure the interest. And then, if you could cure the interest, then it would just go back as if the debt had never been right, it had not been accelerated. Now, originally, the bankruptcy court denied the confirmation because it said that the plan did not allow for the default rate of interest to be paid. But then it kind of noted to the debtor and the lender, it said, the bankruptcy court rejected the plan because it did not allow for default rate interest, but noted that no default rate interest would be due if Sagamore could show that its default should be excused or the default is not otherwise due in accordance with the underlying agreement and the applicable non-bankruptcy law. So with that, Sagamore filed an amended plan and proposed that it would pay whatever the bankruptcy court determined was due. And then at the same time, the debtor objected to the creditor's proof of claim and argued that it didn't owe default interest because the demand was improper because it did not give notice to the proper place. Because it was under the loan documents, the demand was supposed to, any notice was supposed to go to both the debtor and its New York counsel. So, the bankruptcy court confirmed the plan and said that because the notice was defective, everything that flowed from the defective notice was in error, and the debtor could cure by paying the non-default interest. So then it went to the district court. The district court also confirmed or affirmed what the bankruptcy court said, and then it went to the 11th Circuit. So the 11th Circuit has a pretty interesting analysis about basically the plain reading of your loan documents. It said the debtor waived notice of default. So it doesn't matter that the default notice was defective because the lender never had to give default and to have the interest be the default rate of interest and or to otherwise accelerate the loan. So the 11th Circuit affirmed the district court's determination that the borrower may be required to pay the default interest to reinstate the loan, but it reversed the district court's determination that the lender had waived default interest. What I find interesting about this case is that the bankruptcy court is trying to be a court of equity, right? It's trying to find a solution where it could say that the default was, the notice was somehow wrong, and so instead of having to pay default interest, the debtor only had to pay, regular interest to cure, because it's trying to find an equitable resolution, right? But what's interesting is that even though it's a court of equity, it is ultimately the loan documents govern. They were unambiguous, they were clear. The borrower executed a document that said it waives notice. And so I think it's interesting because it's kind of an interplay between the code and curing amended plans and then really the clear language of what your loan documents say. So I felt like the takeaway from that is either party that you represent, you really need to know what your loan documents say, and you need to counsel that accordingly. And it went all, now it's been remanded back down to Judge Crystal, and I looked it up, but it's very recent. I looked it up because now what's being litigated is the attorney's fees that were incurred for all of this. It's $4 million worth of attorney's fees.
Jesus.
And, I mean, you know, when, but, well, it's a big New York, or it's a big, you know, big Miami law firm down there. And so you have to even think more about what is the business solution? You're not doing your client justice to litigate and litigate when you have to think really, right under the loan documents, attorney's fees and costs are borne by the borrower. And so I just think this is something that, right, default, the difference between default rate of interest and regular interest was only 6% now. I mean, it could have, right, the contract was 6 and the default's like 12.
So what's the difference between the interest and the attorney's fees?
Right, and I was trying to figure that out. I mean, and so, you know, think about that, right? I'm sure it's certainly, at most, let's say $1 million was at issue. Well, now it's $5 million at issue, plus trying to cure it all. And because the loan hadn't matured, this is an unusual circumstance because this is a debtor that found funding, but found funding to cure a non-matured loan, and then was able to advance a plan that basically just, you know, cured and went forward. But it's a telling story about really knowing all of your documents in my eyes, and thinking and trying to give a more business solution to the situation than really fighting over the difference. So that's this case. The second case that the 11th Circuit recently ruled on is, and I think a lot of people know about this case, it's In re McLean. It's Greenpoint Credit versus McLean. It's an 11th Circuit case. It came out on July 23rd, 2015. And in that case, it was a case of first impression. It's where the 11th Circuit held that a lender violated the automatic stay when the lender filed a proof of claim in which the underlying debt had been discharged in a prior case. Now you think, like, how does that ever happen? Apparently it does happen. In the first bankruptcy case, the debtors received a discharge of the unsecured debt owed by the lender. The lender had, I think it had foreclosed, and it was a deficiency claim. In the second bankruptcy case, the lender filed a proof of claim for the same debt that was discharged in the first bankruptcy case. The debtors filed an adversary proceeding. Upon filing the adversary proceeding, the lender promptly withdrew its proof of claim. But the adversary proceeding was a violation of the automatic stay and an infliction of emotional distress. The bankruptcy court awarded both compensatory and non-compensatory damages that the court described as coercive sanctions. The district court affirmed both of the damages and then on appeal, the 11th Circuit affirmed and reversed. Now, this is a Chapter 13 case, so it is different than, I think it's different than a Chapter 7 case. Because the focus in this case was that the filing of the proof of claim had emotional distress on the debtors because it increased their plan payments where they couldn't make the plan payments. Now in a 7, right, that wouldn't happen. So I wonder if there would be a different analysis, because how could there be an infliction of emotional distress, because in a 7, the debtor is not doing anything. So I think that's one kind of takeaway, that this is a little different, I would think, than in a Chapter 7 setting. But what the 11th Circuit did was that it said, yes, the lender violated the automatic stay because it improperly pressured the debtor to pay on a debt that the debtor was not personally liable for, notwithstanding the procedural protections afforded by the debtor under the Bankruptcy Code. But the court vacated both of the awards of compensatory and non-compensatory damages, and it remanded it for further proceedings because it determined that the non-compensatory damages were punitive in nature rather than as sanctions, and that's a higher standard, and it basically violated the lender's due process by not having kind of a full-blown out trial. And then it also, the 11th Circuit said it acknowledged that the debtor may receive compensatory damages for emotional distress, but it also remanded it in light of another court case that the 11th Circuit had recently articulated in 2014. So I actually went back and I looked at the underlying case to see what happened, because I was wondering what the amounts were. So they were pretty substantial. The bankruptcy court, so
Who's the bankruptcy judge?
so in this, okay, this is an Alabama case. So the other one, the first case was, I told you, was Miami. It was Judge Crystal. This is an Alabama case. So in the underlying deficiency, okay, it was $11,000. So for $11,000, the creditor, Green Tree, got dinged. $25,000 for emotional distress, and $50,000 for the coercive sanction, basically saying to Green Tree that they need to, revise their procedures. So then I looked to see what happened, and they settled. So they just recently filed a motion to compromise. And in the compromise, so what I said 25 and 50, that's 75. So they settled for $65,000. 22 is exempt funds to the debtors. And then the balance 30, and then the balance is goes to a contingency fee that the attorneys had, and then to the Chapter 13 trustee, which is distributed to the creditor pool, right, is $9,000. So I thought it was really interesting. I represent a lot of FDCPA creditors, Verizon that does a lot of the calling, and they have some kind of intricate system of looking up last 4 digits of the social and addresses, and about whether or not they get notice on bankruptcy pleadings, and they have some kind of intense system software. But right now, in the district court, we're defending for calling when a debtor, when one of the customers has filed bankruptcy and the discharge has been entered. So we'll see how that impacts it. But I think, and I was kind of disappointed that Judge Delano wasn't here, because I think the analysis really, in this case, is different if it was a Chapter 7. Because there's no emotional distress and it doesn't impact the debtor at all.
So Laura, did you say that it was a deficiency for which she was not personally liable?
Because the debtor had filed bankruptcy already and that debt had been discharged.
Oops.
Right, right. So
Probably
it's a,
713 probably.
Yeah, but in the second law, it'd be all the other creditors that would be the ones who were impaired by the filing of a potential large deficiency claim.
But
Yeah, I
who-
can
Sorry,
see the guy at
discharge.
Bank of America is really emotionally overwrought.
but who, but does the, but
I'm
what,
talking about the emotional distress, I'm talking about the
Just kidding.
Well, what's the-
reduction in the dividend.
but what's the, so does the Chapter 7 trustee have a claim against the wrong filing? Besides just objecting to it, what's the, right, you're stepping into the shoes
Yeah,
of the,
well, I could do anything but object.
right, don't you think the Chapter 7 trustee could just object? How is the trustee gonna get actual money for the wrongful filing?
The trustee doesn't. It's a post-petition law. How does Diane get a post-petition law that belongs to the debtor?
Well, but
It doesn't belong to the debtor.
it doesn't really, because it's a claim that's, you're seeking a claim from estate funds.
They claimed it as a 362 violation.
Yeah,
It does belong to the debtor.
because as it was a Chapter 13.
But in a 13, yeah, but I
No,
don't
let's
know.
talk about 7.
How's the debtor damaged in the 7?
They made a claim, it depends what they filed for a proof of claim and what they decided to do with it.
Right.
You'd probably have to do an analysis of what the, if there was
It's easy to
other
object to the,
creditors and
right,
if
it's
there
easy
was
to
a-
object to the claim, but how do you get money from the lender for violating
Didn't the 11th
anything?
Circuit say that they violated the automatic stay?
They did, but it was in the, right, but does the Chapter 7 trustee have that right?
Why would they have the right on a violation of stay? It's not against her.
But then, okay, so then, but does the debtor,
But why would the debtor have any rights?
In a
Because at that
seven.
point, the debtor
the,
Look,
the debt's been discharged.
Yeah,
So I'm not sure that the debtor has any rights
Right.
either, so
Right, so I think
it's
this
probably a moot point in the 7.
I think it's a moot point in the 7. Yeah.
and a 13, it can impact the.
Well, yeah, this was a 13.
Yeah.
That's why when I was looking to see what chapter it was, I thought, but I don't really think that a 7 trustee could get anything out of
And
this.
then you have the problem with the plan where whatever funds you get, who's it belong to? Because now you gotta have to acquire property.
Well, and that's how they had that allocation there in that other agreement, you know.
Right, they split, or the debtor got the majority of the compensatory damages they got originally, 22,000. Well, I don't know what Alabama's exemption is.
I would assume that's what their exemption is.
Right, right.
Sounds like it's federal exemptions.
Is that high?
Could be.
20.
Yeah, it could, because under D5,
20%.
they have the catch-all under D5.
Yeah.
Yeah.
So,
So I thought it was a really interesting case, but then in my analysis, I'm thinking it's really maybe just good for a 13 debtor. I can't see, since I do represent a lot of Chapter 7 trustees, I don't see how we could get a piece of that, as creative as I am. I was thinking about it. The last case I wanted to talk about was, it's called PSN Liquidating Trust versus Intelsat. The debtor was PSN USA. It just came out on September 4th, 2015. And this was a confirmed Chapter 11 plan that established a liquidating trust to pursue Chapter 5 causes of actions. The liquidating trustee filed an adversary proceeding to recover payments that the debtor made pursuant to a contract that the debtor's corporate parent had executed. So the liquidating trustee filed it under a constructive fraud theory. On summary judgment, the bankruptcy court said that the debtor received reasonable equivalent value because the debtor used the services under the contract, and the parent and the debtor shared an identity of interest such that any benefit the parent received under the contract also indirectly benefited the debtor. The district court affirmed and the 11th Circuit affirmed as well. So this, I think, is a really good case for the overzealous trustee, because I'm actually in a case where I'm defending where an overzealous trustee is seeking monies back. And this case now in the 11th Circuit basically says that reasonable equivalent value, that a debtor can receive an indirect benefit, and that's reasonable equivalent value. That line of reasoning, I believe, has been adopted in other circuits, and it really wasn't clearly adopted in the 11th Circuit. And I thought there are some really good quotes in that case.
What sort of indirect benefit was at issue?
So in this case, the debtor was a, let me see, it was some kind of, what is the word, satellite contracting service. And so the parent company really held no assets but the debtor. But for whatever reason, the service contract was in the name of the parent company. But the debtor is the one that did all the service work, got all the benefit of the service work, and in return paid the monthly service fee or whatever it was under that contract, even though the name of the other entity was the parent company. And so the 11th Circuit cited does a very good analysis about kind of what's the definition of value under the Bankruptcy Code, what's the definition of value under the Uniform Fraudulent Transfer Act, what are the tests, and it came down to basically adopting this economic benefit upon the debtor, either directly or indirectly, is to be considered value, and therefore the defendant won. And this is all on summary judgment, which I thought was even more impressive. It also adopted that reasonable equivalent value does not have to be dollar for dollar. And so I thought that was also very good. This is a great case for defending fraudulent transfer actions. And I mean, I think it's a great case to waive in front of trustees when they think just because it's a parent-subsidiary relationship and you know, the contract's in one name and not the other, and the other one pays for it, it's not an automatic win that the debtor didn't receive any kind of benefit. And now it's really leaning, or the case law is changing to an indirect benefit might fulfill reasonable equivalent value. So I thought it was a good case. It definitely kind of puts the kibosh on the Tusa case. It cites Tusa. I think it clarified maybe splits amongst the lower courts in this district, and so I thought it was good. It was a good case. That was kind of quick. Does anyone have any questions? So those were kind of the cases I focused on. I know that I started reading another case, but then I realized it was Judge Delano's case, and I assume she talks about it all the time, the Moore case. So this is Robert Moore, and it was the, I think I was in her courtroom when she was talking about it. It's about these people who were interior designers, and it was,
It was what, I was the trustee.
yeah.
Alan Hamish's case.
Yeah, that was my case.
Yeah. And so
Go ahead.
no, and so anyways, I thought
That's
it was,
not the peephole guy, wasn't it, or the guy?
it was a discharge, right? So that,
Okay.
it was a 727A5, but she ruled in favor of of the
Yes.
debtors,
Yes,
right?
yes.
Yeah, saying that they did not have to demonstrate where every single dollar went.
Yes, there was issues regarding the LLC and whether they were taking money in personally, which they weren't.
Right.
And what bills were being paid and so forth. Yeah, they sold some assets. That was the issue.
Right, so it
One
was,
of the issues.
yeah, it was pretty impressive. I mean, it went all the way up to 11th
To
Circuit.
yes.
And they affirmed Judge Delano saying that you don't have to, basically, you don't have to explain every single loss and every single dollar and where it went to, and that the debtors adequately explained it to get over the 727. So, I thought it was a good case. So that's it.
Not volunteering to testify.
All right, thank you, everyone. Thank you, Lara. For those of you that walked in late, there's some lunch in the back. There's also a tray of cookies. I haven't seen too many cookies on folks' plates, so
It's in my stomach.
thank you for coming and enjoy the goodies.
Awesome.